Welcome to episode 9 of my series on Family Court Uncensored. Today we're tackling coercive control, what it means legally, how it's applied in family court, and why the gap between definition and application destroys fathers' relationships with their children. The episode is about the legal definition of controlling or coercive behaviour under Section 76 of the Serious Crime Act 2015, how that definition expanded through the Domestic Abuse Act 2021, and most importantly, how family courts apply these definitions in practice. And here's what you need to understand. These definitions are so broad that normal relationship conflict now meets the legal criteria for abuse, and they're applied almost exclusively to fathers. Mothers exhibiting identical behaviours are rarely assessed, rarely questioned, rarely labelled. And why? Because the system operates on an explicit policy of protecting the primary carer from scrutiny that might undermine their emotional welfare, which in practice means protecting mothers from the same standards of accountability applied to fathers. The result is a system where everyday men are being classified as coercive controllers based on nothing more than one person's uncorroborated descriptive account, whilst their ex-partners exhibiting identical or worse behaviours are shielded from examination. You face the presumption of guilt. She faces presumption of credibility. You must prove your innocence. Her word alone is treated as sufficient proof of guilt. By the end of this episode, you're going to take an assessment. We're going to ask you questions about your past relationship, normal questions about normal conflict, and you're going to see how many of your answers would meet the legal definition of coercive control under current family court practice. Then we're going to show you why the same questions are almost never asked of mothers. This isn't about excusing real coercive control. Real systematic terrorising of a partner, real control that strips somebody of their autonomy, that's abuse and it's serious. But what we're going to demonstrate today is that the legal definition is expanded so far beyond genuinely coercive behaviours that almost any separated couple could have their relationship characterised as coercive control, and the system deliberately chooses to only examine the father's behaviour whilst protecting the mother from equivalent scrutiny. Quick note before we dive in. This episode focuses on how coercive frameworks are applied to fathers in family court and why mothers are often protected from equivalent scrutiny. This isn't because coercive control only happens one way. Research shows controlling behaviours exist in both directions. But the family court practice applies these definitions asymmetrically, almost exclusively scrutinising fathers whilst protecting mothers as primary carers. That's what we're examining today, not whether coercive control is real, but how the legal definition is weaponised against fathers specifically. Let's start with the legal framework. Coercive control became a criminal offence in England and Wales in December 2015 under Section 76 of the Serious Crime Act 2015. This was groundbreaking legislation designed to criminalise patterns of controlling behaviour that don't necessarily involve physical violence. Section 76 defines controlling or coercive behaviour as behaviour that occurs repeatedly or continuously that has a serious effect on the victim and that the perpetrator knows or ought to know will have a serious effect. The behaviour must be controlling or coercive, meaning that it makes the victim subordinate or dependent, or it isolates them from sources of support, or it exploits their resources, or it deprives them of means needed for independence, or it regulates their everyday behaviour. Notice the language, ought to know. Not that you intended to control, but that you ought to have known your behaviour would be controlling. This is a negligent standard applied to relationship dynamics. You can be found to have committed controlling behaviour even if it wasn't your intent, even if you didn't realise the impact, because you ought to have known. And what counts as regulating everyday behaviour? What counts as having a serious effect? These are judgment calls, and in family court they're being made by CAFCASS officers and judges who often have no training in psychology, no clear methodology and significant bias. Then in 2021, the Domestic Abuse Act further expanded the definition. The Act defines domestic abuse very broadly. Section 1 states that behaviour is abusive if it is violent, threatening, or if it has a substantial adverse effect on the victim's well-being. Abuse includes physical abuse, sexual abuse, emotional abuse, psychological abuse, economic abuse, and controlling or coercive behaviour. Physical and sexual abuse have relatively clear definitions, but emotional abuse, psychological abuse, economic abuse, and controlling or coercive behaviour, these are incredibly subjective and elastic concepts. What counts as having a substantial adverse effect on someone's well-being? Who decides? Based on what standard? The legislation is deliberately broad. It's designed to catch behaviours that fall short of physical violence but are still genuinely harmful. The problem is how it's being applied in practice, particularly in family court. Now let's talk about Practice Direction 12J. This is the court practice direction that governs how allegations of domestic abuse, including coercive control, are handled in family court proceedings. It was updated in 2017 and it fundamentally changed how fathers are treated. Under Practice 12J, if allegations of domestic abuse are made, even if they're not proven, the court must conduct a fact-finding hearing to determine about whether abuse occurred. The standard of proof is the civil standard balance of probabilities. That means 51% likelihood is enough, not beyond reasonable doubt like criminal court, just more than not. And here's the critical part. The court are required to consider the allegations in the context of a pattern of coercive and controlling behaviour. Individual incidents that may seem minor on their own can be reframed as part of a pattern that amounts to coercive control. So a text message argument about money becomes evidence of economic abuse or financial control. A disagreement about your partner going out becomes evidence of isolation or controlling social relationships. Checking where your partner is becomes evidence of surveillance and monitoring. Asking about household decisions becomes evidence of regulating everyday behaviour. All of these normal relationship conflicts, when viewed through the lens of coercive control, can be reconstructed as abuse. But here's what Practice 12J doesn't tell you. In practice, these assessments are almost never conducted equally. The system operates on what I call the primary carer protection principle. This is an unwritten but universally applied rule. Do not scrutinise the primary carer's behaviour in ways that might undermine their emotional welfare, because doing so could harm the child who depends on them. Sounds reasonable, doesn't it? Doesn't destabilise the main parent? Except here's the problem. The primary carer is almost always the mother. And this principle is used to justify not asking the mother the same questions that the fathers face, not examining their behaviour, not applying the same standards, because to do so might upset her, might undermine her confidence, might affect her ability to care for the child. So the father is subjected to intensive scrutiny for coercive control. Every argument is analysed. Every text message is examined for evidence of control. Every decision he made is questioned for signs of regulation or domination. But the mother? She's protected from that scrutiny. Her account is taken at face value. Her behaviour isn't questioned because questioning it might undermine her emotional welfare as primary carer. This creates a fundamental asymmetric system. You face investigation for coercive control. She faces validation. You must prove your innocence. She merely must describe her experience, and her description alone is treated as sufficient proof. And here's the most insidious part. The mother's uncorroborated descriptive account of how your behaviour made her feel is considered sufficient evidence to make findings of coercive control against you. She says you were controlling, that's evidence. She says your behaviour made her feel subordinate or dependent, that's evidence. She says arguments had a serious effect on her well-being, that's evidence. You say she was controlling, that's defensive, that's minimising, that's blame shifting. You say her behaviour affected you, that's irrelevant. You're not the primary carer. You say control was mutual, that's denying her experience. The system has created a framework where her subjective description of how your behaviour made her feel is treated as objective evidence of coercive control, whilst your subjective description of how her behaviour made you feel is dismissed as manipulation or deflection. Let me give you a concrete example of how this works in practice. During a CAFCASS assessment, the officer will ask the mother, how did his behaviour make you feel? Did you feel controlled? Did you feel subordinate? Did you feel isolated? Did you feel unable to make your own decisions? These questions are designed to elicit emotional responses that will then be characterised as evidence of coercive control. But the father? He's rarely asked, how did her behaviour make you feel? Did you feel controlled? Did you feel undermined? And even if he volunteers this information, it's dismissed. And why? Because he's not the primary carer. So his emotional welfare isn't the priority. Or because men aren't supposed to be affected by women's behaviour in the same way. This is structural bias. It's not individual CAFCASS officers being unfair, though some are. It's a system designed from the ground up to protect mothers from scrutiny for coercive control while subjecting fathers to intensive examination for the same behaviours. And it's justified by the primary carer protection principle. We can't upset the main parent. Now, you might be thinking, surely, if there's evidence of mutual controlling behaviour, the court considers it. Sometimes, but not the way you think. When evidence emerges that the mother was also controlling, exhibited coercive behaviours, or tried to regulate the father's behaviour, the system has built in explanation: reactive abuse. The concept of reactive abuse says that victims of coercive control sometimes fight back, sometimes respond with their own controlling behaviour as a form of self-defense or survival. This is a legitimate concept when applied appropriately. Some victims of genuine coercive control do develop controlling responses, but in family court, reactive abuse is applied almost exclusively in one direction. When evidence shows a mother was controlling its reactive abuse, she was defending herself against control. When the evidence shows the father was controlling its primary coercive control, he's the perpetrator. Same behaviour, different interpretation based solely on gender. I've seen cases where mothers admitted to monitoring fathers' communications, controlling financial decisions, dictating who father should spend time with, and it was characterised as understandable reaction to his underlying controlling behaviour. Meanwhile, fathers who ask reasonable questions about household decisions are characterised as coercively controlling. The system assumes male perpetration of coercive control and female victimhood that interprets all evidence through that lens. Anything that fits that narrative is accepted. Anything that contradicts it is explained away. So let's do the assessment. I'm going to ask you a series of questions about your past relationship. Answer honestly. Every question describes a behaviour or situation that, under current practice, could be cited as evidence of coercive control in a CAFCASS report or court proceeding if you did it. Then I'm going to show you why the same questions are almost never asked about your ex-partner's behaviour and why her answers wouldn't matter even if they were. Question 1. Did you ever express an opinion about how money should be spent in your household? If yes, that can be framed as economic control or exploiting resources. But was this question asked about her? Did she control financial decisions? If she was the primary earner or managed the household finances, was that examined as potential economic control? Question 2. Did you ever ask your ex-partner where she was going or who she was meeting? If yes, that can be characterised as surveillance, isolation, or attempts to regulate everyday behaviour. Did anybody ask if she questioned where you were, who you spent time with, or what you were doing? If she did, was that characterised as coercive control or as reasonable relationship communication? Question 3. Did you ever express concern or disapproval about your ex-partner's choice of friends? If yes, that can be characterised as isolating behaviour or controlling social relationships. Did she ever express concern about your friendships? Was that scrutinised as isolation or control? Question 4. Did you ever make a decision about your household, your child, or finances without consulting your ex-partner first? If yes, that can be characterised as making her subordinate, denying her autonomy, or regulating household decisions. How many decisions did she make without consulting you? Was that examined as control, or was it accepted because she was the primary carer with the right to make daily decisions? Question 5. Did you ever express frustration when your ex-partner made plans without telling you, especially if those plans affected you or your child? If yes, that can be framed as attempting to regulate her behaviour or punishing her for exercising autonomy. Did she ever get frustrated when you made plans? Was her frustration examined as attempts to control your behaviour? Question 6. Did you ever suggest that your ex-partner should handle household tasks in a certain way, or express that you preferred certain routines or arrangements? If yes, that can be characterised as regulating everyday behaviour or making her subordinate. Did she have expectations about how you should contribute to the household? Was that examined as regulation or control? Question 7. Did you ever get upset or withdraw when your ex-partner didn't want to spend time with you or choose to do something else instead? If yes, that can be framed as emotional manipulation, punishing her for exercising independence, or making her feel guilty for having autonomy. But did she ever react negatively when you chose to do things without her? Was that characterised as coercive behaviour? Question 8. Did you ever refuse to discuss something when your ex-partner wanted to talk about it, or need time and space before addressing an issue? If yes, that could be framed as stonewalling, withholding communication as punishment, or controlling the emotional dynamic of their relationship. Did she ever refuse to discuss issues Was her need for space respected while yours is characterised as coercive withdrawal? Question 9. Did you ever insist you were right in an argument, refuse to apologise when your ex-partner wanted you to, or continue debating a point after she wanted the discussion to end? If yes, that can be framed as dominating behaviour, refusing to respect her boundaries, or prioritising your need to win over her emotional well-being. Did she ever insist she was right? Refuse to apologise, continue arguments you wanted to end. Was her behaviour characterised as domination or coercive control? Question 10. Did you ever express that you felt your ex-partner's decisions or behaviours were affecting you negatively, the house negatively, or your child negatively? If yes, that can be framed as attempting to make her feel subordinate to your judgment, controlling her through your criticism, or undermining her autonomy by suggesting her choices need your approval. Did she criticise your decisions, suggest your behaviours were harmful? Was that examined as control? How many of those questions did you answer yes to? If you answered yes to even 3 or 4, congratulations. Under current family court practice, there's enough material to construct a narrative of coercive and controlling behaviour that meets the legal definition under Section 76 of the Serious Crime Act. If you answered yes to 7 or more, you could easily be characterised as demonstrating a pattern of coercive control that meets the threshold for serious concern about your child's welfare in your care. And here's the thing. I would bet substantial money that your ex-partner would answer yes to many of the same questions if they were asked about her behaviour toward you. Did she express opinions about money? Did she ask where you were? Did she have expectations about household tasks? Did she express jealousy? Did she make you feel guilty? Did she refuse to discuss issues when she didn't want to? Of course she did, because these are normal relationship dynamics. These are things that happen in virtually every romantic relationship, especially relationships that are struggling or ending. But here's the critical difference. She will almost never be asked those questions in the context of coercive control. And even if evidence of her controlling behaviours emerges, it will be explained away, minimised or justified, and why? Because of the primary care protection principle. Let me explain how this works in practice. During a CAFCASS assessment, when coercive control allegations are made, the officer's job is to assess risk to the child. In theory, that means assessing both parents' behaviour for signs of coercive control, but in practice it means investigating the father for coercive control whilst protecting the mother from equivalent scrutiny. The mother is interviewed first. She describes the relationship through the lens of coercive control. She talks about how the behaviour made her feel controlled, subordinate, isolated, dependent. She provides examples of arguments, conflicts, incidents. Her account is detailed, emotional, compelling, and here's the key. Her account is taken as evidence of coercive control, not allegations requiring corroboration, not claims requiring investigation, evidence. Then the father is interviewed. He's asked to respond to her allegations of coercive control. Notice the framing, allegations. He's already on the defensive. He tries to prove context, alternative explanations, evidence that control was mutual, that he wasn't being controlling, but everything he says is filtered through the lens of, is he minimising his coercive control? Is he blaming the victim? Is he showing insight into his controlling behaviour? If he admits to any of the behaviours she's described, that's evidence of coercive control. If he denies them, that's lack of insight or dishonesty about his controlling patterns. If he says she did the same things, that's deflection from the coercive control. He's in a no-win situation. But the mother is protected from the same scrutiny for coercive control. The CAFCASS officer doesn't interrogate her account, doesn't ask whether her behaviours were also controlling, doesn't examine her behaviour with the same intensity for signs of coercive control. And why? Because to do so would be to undermine the primary carer, to question her credibility, to suggest she might be equally responsible for controlling dynamics in the relationship. And that might affect her emotional welfare, which might affect her ability to care for the child. This is explicit policy in some jurisdictions. Social workers and CAFCASS officers are trained not to challenge primary carers in ways that might undermine their confidence or emotional stability. The theory is that the child depends on this parent, so we can't destabilise them to examine allegations of their own coercive control. But this creates a system where one parent is protected from accountability for coercive control, whilst the other is subjected to intensive investigation for the same behaviours. And the protected parent is almost always the mother, because she's almost always the protected carer, because the system has already determined that children belong primarily with their mothers. It's a circular logic. Mothers are primary carers, therefore we must protect them from scrutiny for coercive control. Therefore we don't examine her controlling behaviours. Therefore we don't find evidence of coercive control by them. Therefore they remain the safe primary carers. Meanwhile, fathers are subject to scrutiny. Their behaviour is examined intensively for coercive control. Evidence is found because the definitions are so broad that normal relationship conflict qualifies. Therefore they're characterised as coercively controlling risks. Therefore contact is limited. Therefore they can't become primary carers. The system perpetuates itself, and it does so deliberately, justified by the primary carer protection principle. Now let's talk about the standard of evidence for coercive control. When a mother alleges coercive control, what proof is required? In practice, very little. Her descriptive account of how his behaviour made her feel controlled, subordinate, isolated or dependent is treated as sufficient. She doesn't need witnesses to her feelings of being controlled. She doesn't need contemporaneous recordings. She doesn't need police records or medical evidence. She just needs to describe her subjective experience of being coercively controlled convincingly. This is something called the lived experience standard. Her lived experience of the relationship as one of coercive control is valid. Her feelings of being controlled are real. If she felt controlled, then controlling behaviour occurred. If she felt subordinate, then behaviour making her subordinate occurred. Her internal emotional state is treated as subjective evidence of his external coercive and controlling behaviour. But the same standard is not applied to fathers. If he describes feeling controlled, that's not evidence she was coercively controlling. If he describes feeling undermined or subordinate, that's not evidence she engaged in coercive control. His lived experience of being controlled doesn't count the same way as hers does. But why? Because he's not the primary carer, so his emotional welfare isn't the priority. And because the system assumes men don't experience coercive control from women in the same way. This creates a fundamental inequality in the standard of proof required to establish coercive control. She must merely describe her feelings of being controlled. He must prove his behaviours weren't controlling. She's presumed credible about her experience of coercive control. He's presumed guilty of coercive control until proven innocent, and even then, always under suspicion. Let me give you a concrete example. In a CAFCASS report addressing coercive control allegations, you might see a paragraph like this. Mother reports father frequently checking her phone without permission, questioned where she had been, and became angry when she wanted to spend time with friends. Mother states that this made her feel controlled, isolated, and unable to exercise independence. I'm satisfied that father's behaviour amounts to controlling and coercive behaviour as defined by Section 76 of the Serious Crime Act 2015. Notice what just happened. Mother reports, mother states, and based solely on her statements about her internal feelings of being controlled, the CAFCASS officer is satisfied that coercive control occurred. No corroboration, no investigation of whether her account is accurate, no consideration of whether his behaviour was reasonable in the context, no examination of whether she exhibited similar controlling behaviours, just her word about being controlled, treated as proof of coercive control. Now imagine the reverse. Father reports that mother frequently criticised his parenting, made unilateral decisions about the child, monitored his communications, and threatened to stop contact during arguments. Father states this made him feel controlled, undermined, and powerless. Would CAFCASS officer write, I am satisfied that mother's behaviour amounts to controlling and coercive behaviour? Almost never. Instead, you'd see father makes allegations of coercive control against mother, which she denies. Mother explains that she raised legitimate concerns about his parenting and needed to make decisions in the child's best interests. I do not find the father's allegations of coercive control to be credible. Same type of behaviour, same type of evidence, one person's account of their subjective experience of being controlled, completely different conclusions based solely on who made the allegation of coercive control. This is the presumption of guilt I mentioned earlier regarding coercive control. You are presumed guilty of any allegation of coercive control made against you unless you can prove otherwise, and the standard of proof required for you to disprove coercive control is much higher than the standard applied to her allegations. She only needs to describe feeling controlled. You need documentary evidence, witnesses, contemporaneous records, expert reports to disprove coercive control, and even then your evidence will be scrutinized for credibility whilst her description of feeling controlled is accepted at face value. Why does this happen with coercive control allegations? Partly because of gender bias, the assumption that men perpetrate coercive control and women are the victims of it. Partly because of the primary carer protection principle. Don't undermine the main parent even to examine their potentially controlling behaviours, and partly because the system is fundamentally risk averse. Courts and CAFCASS are terrified at making mistakes that result in a child being harmed by an abusive, coercively controlling parent. If they allow contact and something bad happens, they'll be crucified in the media and in serious case reviews. So they err on the side of caution with coercive control allegations, which means restricting contact whenever there's any allegation of coercive control, no matter how thin the evidence. But the risk aversion about coercive control is applied asymmetrically. The risk of a father being coercively controlling and harming a child is taken extremely seriously. The risk of a mother being coercively controlling or harming a child through alienation, through false allegations of coercive control, through undermining the father's relationship is barely considered. And why? Because the system doesn't see mothers as capable of coercive control in the same way as it sees fathers. So you face a system that is designed to find you guilty of coercive control. Your ex-partner makes allegations based on nothing more than her subjective description of how your behavior made her feel controlled. Those allegations are treated as evidence of coercive control. You're required to prove they're false, but the standard of proof is impossibly high. Meanwhile, her potential controlling behaviour is protected from equivalent scrutiny because examining it might undermine her emotional welfare as the primary carer. This is not justice. This is not child protection. This is structural bias that systematically applies the legal definition of coercive control to fathers while protecting mothers from the same scrutiny, favouring credibility over evidence, and treating subjective feelings of being controlled as objective facts. So what do you do if you're facing allegations of coercive control? First, understand what you're up against. This isn't just defending against specific allegations. You're fighting a system designed to believe her allegations of coercive control and doubt your denials. Knowledge of that bias is power. Second, document everything. Since her word alone about feeling controlled is treated as sufficient proof of coercive control, you need evidence to counter it. Keep records of all communication. Keep evidence showing mutual decision making, not unilateral control. Keep witnesses who can verify your account of the relationship not being coercively controlling. You need proof because your word alone won't be enough against allegations of coercive control. Third, insist on equal scrutiny for coercive control. In court or in CAFCASS assessments, ask directly, has the mother been assessed for controlling or coercive behaviour? Has her behaviour during the relationship been examined through the same lens of coercive control? Have the same questions about control, subordination, isolation, regulation of behaviour been asked of her? If not, why not? Force the system to confront its own double standard in applying coercive control frameworks. Fourth, challenge the primary carer protection principle when it's used to avoid examining her behaviour for signs of coercive control. Yes, children need stability, but children also need protection from all forms of coercive control, regardless of which parent is the perpetrator. If the principle of protecting the primary carer means not examining whether the parent engaged in coercive control, the principle is being misused. Fifth, challenge subjective evidence of coercive control. If allegations are based solely on her description of how she felt controlled, that's not sufficient proof of coercive control under Section 76. Feelings of being controlled are valid, but are not objective evidence of controlling behaviour. Push for corroboration. Push for evidence beyond her say-so about feeling controlled. Sixth, provide evidence of mutual relationship dynamics, not to excuse your own behaviour, but to show the court that relationship difficulties were bidirectional, not unilateral coercive control. If arguments were mutual, if both partners had expectations and boundaries, if both partners influenced decisions, that context matters. It demonstrates normal relationship conflict, not coercive control. Seventh, don't accept the reactive abuse explanation for her controlling behaviours unless there's actual evidence. If evidence shows she was controlling, monitoring, regulating your behaviour and making you subordinate, the claim that it was reactive to your coercive control requires proof. What was she reacting to? When? Is there evidence that her controlling behaviours only occurred in response to yours? Or is that post hoc justification? Eighth, demand trained professionals when coercive control is alleged. CAFCASS officers making findings about coercive control should have specific training in psychological assessment, trauma, domestic abuse dynamics, and the specific legal framework of Section 76. If they don't, their conclusions about coercive control lack credibility. Ask about their qualifications and methodology for assessing coercive control. Ninth, know when you need expert evidence on coercive control. If CAFCASS make findings of coercive control against you based on flimsy evidence, consider instructing an independent psychologist to assess the situation properly. Expert evidence can challenge poorly evidenced CAFCASS conclusions about coercive control. 10th, never give up challenging bias in the application of coercive control frameworks. Every time the double standard appears, name it. Every time she's protected from scrutiny for controlling behaviours you're accused of, point it out. Make the bias visible. Let me be absolutely clear. I'm not saying that coercive control doesn't exist. I'm not saying that real coercive control isn't serious. I'm not saying that fathers are never guilty of coercively controlling. Some are. And when genuine coercive control has occurred, the system should absolutely protect children and victims. But the system has created a legal framework where normal relationship conflict is reclassified as coercive control when attributed to fathers, whilst identical controlling behaviour by mothers is protected from scrutiny. Where one parent's subjective feelings are being controlled or treated as objective evidence of coercive control, while the other parent's experience is dismissed. Where the burden of proof for coercive control falls entirely on the accused father, while the accusing mother faces no requirement to corroborate her claims of being coercively controlled. That's not safeguarding from coercive control, that's bias. And it's destroying families and traumatizing children who are being separated from loving, non-coercively controlling fathers based on nothing more than one parent's uncorroborated allegations of coercive control interpreted through a lens of gender bias and primary carer protection. The solution is equal application of coercive control standards. If you're going to assess one parent for coercive control, assess both. If you're going to accept one parent's subjective account of feeling controlled as evidence, accept both. If you're going to scrutinise one parent's behaviour intensively for signs of coercive control, scrutinise both. Equal standards for assessing coercive control. Equal evidence requirements for proving coercive control. Equal protection from unjust accusation of coercive control. And the primary care protection principle needs to be exposed for what it is. A justification for not holding mothers accountable for their own potentially coercive and controlling behaviours. Yes, children need stability, but they also need truth. They need protection from all coercive control, not just coercive control by fathers. And they need the system to make decisions based on evidence, not on assumptions about gender and who is more likely to be coercively controlling. Until that happens, fathers will continue to face a system rigged against them from the start regarding coercive control, where her word about feeling controlled is enough to condemn you, but the word is never enough to defend yourself, where normal relationship conflict is proof of your coercive control, but evidence of her controlling behaviours is explained away or ignored. If you're going through allegations of coercive control, know that you're not alone. Thousands of fathers face the same bias system, the same impossible standards, the same presumption of being coercively controlling, the same protection given to their ex-partners while they're subjected to intensive scrutiny for coercive control. Document everything, challenge the double standard in how coercive control is assessed, demand equal application of coercive control frameworks, insist on evidence, not just allegations, refuse to accept that her subjective feelings of being controlled are sufficient proof of your objective coercive control, and never stop fighting for your child. The system won't change unless we force it to change. Every father who challenges bias in coercive control assessments, who demands equal treatment, who refuses to accept unjust findings of coercive control makes it slightly harder for the system to maintain its current practices. If you have found this episode valuable, please share it. Other fathers need to understand what they're facing regarding coercive control allegations. This is general education, not legal advice. Speak to a qualified family law solicitor about your specific situation. I'll see you in episode 10.